All right. Hi. Good afternoon. This is Billy Tarasio from Modern Law, and we're here with our live webinar seminar series, broadcast live to you from Mesa, Arizona. If you have any questions at all on Arizona family law issues, send them our way. You can either put them in the comments or send them via Messenger. That's where most people are sending questions lately, and it's working really well. So go ahead and send them over via Messenger. So I am an Arizona licensed family law attorney. And the reason I keep saying that is because more and more people have been contacting me recently for questions or with issues that are outside the state of Arizona. And I want to be really clear that we at Modern Law are only licensed to provide advice in Arizona. The other thing to note is that what we're doing today, what we do every time that we do a seminar, is not legal advice. We aren't analyzing your situation. We're not telling you what you should necessarily do. We are giving you lots of information because the fact is that roughly 85% of people end up representing themselves. So the more information you have, the better. And today we're going to talk about spousal maintenance. And we've talked about this before, but the video didn't work. And I got a question, I think it was late last night, about spousal maintenance, and I wanted to send her this video, but it wasn't recorded properly. So we are going to talk about it again. We're going to make sure that it gets recorded so we can send it to anyone who has questions about spousal maintenance. And also because it's hard. This is a hard topic. This person reached out to me and she says, I want to know what I can expect for spousal maintenance. And there's simply no way that I can fire off an answer that would be anywhere close to satisfactory. So that's why we do the video. We'll talk about it for roughly a half an hour. And then we'll dive into any of your questions on this or any related issues. I'm drinking iced tea from Costa Vida, so plug for Costa Vida here at Dana Park. And with that, we'll dive in. So spousal maintenance, formerly known as alimony, can be some of the hardest cases to navigate. The reason I say that is because with property issues, it's pretty simple. It gets divided. And it gets divided almost all the time equally. Of course, there's nuances. Of course, there are days and times where that's not the case. But most of the time, you add up all the property you have, you figure out the net worth, and you divide it. Child support is also pretty straightforward. I say this, and then at the same time, I know that we have cases that we fight on every aspect of child support. But in general, child support is pretty simple. You get all the inputs, you put it in, and it comes out with a number. Even custody and parenting time in Arizona is pretty simple. If you have two good parents, the court's going to want both parents spending as close to equal time, both weekend and weekday parenting time as possible. That's the default. So what about spousal maintenance? What's the default with spousal maintenance? There is no default. It's a two-part analysis, and today we're going to go through all of the various factors that are used to determine whether someone gets spousal maintenance. We have a lot of experience with spousal maintenance. We've secured indefinite or permanent spousal maintenance awards, temporary spousal maintenance awards, and defended against unjust modification claims or requests for spousal maintenance. So it's one of the issues that, because it's so tough, you may want to actually consult an attorney for some analysis and some guidance on. But let's talk about how it works. So it's covered by the Arizona Revised Statute 25319. And that's the law that sets out how spousal maintenance works. There's probably more misconceptions and myths around spousal maintenance than really any other area. You'll hear people say things like, well, I've been married for 10 years, so I get maintenance, right? Or I've been married for 20 years, so my maintenance will be 30% of his income, right? Or things like that. And it's just, none of those myths are true. And if you plead it incorrectly, if you fail to ask for it, or if you ask for it the wrong way, it can really hurt you. Waiving spousal maintenance in a divorce means you can never go back and get it. So you can't modify your divorce decree. It's harsh. Sometimes it's harsh. But yeah, you get one shot on this. if you end up getting divorced and you waive spousal maintenance and later you lose your job and your ex is making 3 times what they were making before, you cannot go back and ask for spousal maintenance. So chat with us if this is an issue that pertains to you, for sure. Chat with somebody. The affidavit of financial information is probably the most critical piece of information when determining spousal maintenance. And the reason is that the analysis goes like this. First, part A of 25.319, do you qualify for spousal maintenance? There's 4 categories that would allow you to qualify for spousal maintenance, but the bottom line is usually you can't afford to pay your bills or meet your reasonable needs. My son just called the phone. So did the live feed get all screwed up?
No, I just.
Okay, got it. Thanks for calling him. He just got done school calling anyway. So first, do you qualify? Usually that's because you cannot afford to meet your reasonable needs without maintenance. There's so much we can fight about here. Reasonable needs, what's reasonable? And what if you can afford it, but you don't have anything left over? Like, and does it even matter how much the other person makes? Not really. If you can pay all your bills and meet your reasonable needs without spousal maintenance, you probably don't qualify. There's a couple other ways you might qualify. Let's say you supported this person through school or something like that. There might be some ways we can look at spousal maintenance there as well. But you have to first qualify for maintenance. Only if you qualify under Part A do we look at, okay, well, how much money does the other party make? And how long were you married? And do you have kids in college you have to support? All of the factors that you would, and what was your lifestyle like? What were you accustomed to? How did you make career sacrifices that have impacted your ability to earn now? Those are all things that the judges look at after you first prove you qualify. So if you're a nurse and you make $50,000 a year and your spouse is a doctor and he makes $400,000 a year, but you have you live in a house that's paid off and you don't have any debts, you can meet your reasonable needs on $50,000, and it's very likely that a judge will say you don't qualify and you won't get any spousal maintenance. This is why the affidavit of financial information is so critical. The affidavit of financial information is kind of your budget. It's all your sources of income and it's all your expenses. It's hard to do. Most of us don't know what we spend every month on small minutia, car repairs, and you have to figure out all of that really on an annual basis and divide it. It's a massive task. It's really hard to do. And in some cases, it's more critical than others. And in spousal maintenance cases, it's pretty critical, because if you are the person from whom your ex is requesting spousal maintenance, one of the things they're going to look at is, well, how much is available? How much do you have available to pay your ex in maintenance? The affidavit of financial information, which sets out your income and your expenses, will be the main piece of evidence that shows how much money you have available. So if you do your affidavit of financial information kind of half-heartedly, and I add up your income and I add up your expenses, and you've got $4,000 left at the end of the month, then I'm going to know what to ask for. I'm going to know that I can ask for up to $4,000 a month, and you've said these are your reasonable needs, and this is now available. So you need to pay attention to this. It's important. Likewise, if you are requesting spousal maintenance, but you make $50,000 a year, you add up all expenses, and you have $2,000 left over each month, how can I argue that you can't afford to meet your reasonable needs without help? This is very important. It's required. The affidavit of financial information is required in every single case where there are financial issues like child support, spousal maintenance, and even attorney's fees. It's an affidavit, which means you sign it in front of a notary. It's important. You are swearing to the court that the information is valid. It's really hard. What do you need in order to put it together? Your pay stubs, your sources of income. Who else is in your household supporting your bringing in income? Everything okay with the kiddo?
Yep, totally.
Great. Tax returns, monthly expenses, information about your children and their expenses, childcare costs, medical insurance costs, debts, past and current employers. It's comprehensive. There are two types of maintenance. There's temporary spousal maintenance, which means, and I don't mean that's for a short period of time. I mean, temporary spousal maintenance would be something that you secure before your divorce. So you file the petition, or your ex files the petition, and someone, either the petitioner or the respondent, files a motion for temporary orders asking for maintenance. You probably need to be specific about why it is that you need temporary spousal maintenance. What are your expenses that you're unable to pay? And just your temporary spousal maintenance number will not necessarily be your permanent spousal maintenance number. And when I say permanent, I don't mean lasting forever. I mean the maintenance that is ordered at your final trial, or that you agree to on a final basis. So before you file this motion for temporary orders for spousal maintenance, be specific about how much money you need and why. You may also consider asking for things like an order directing someone to pay certain bills, or pay certain expenses on behalf of the kids. All of these are options. You can also ask for attorney's fees on a temporary basis, so that you can ask that your spouse contribute to your ability to hire an attorney. As a practical matter, it's hard to do. The courts are not, in my experience, in my opinion, readily handing money over. They'd prefer to take a joint account and liquidate it and give each person half or something like that. So once you file a motion for temporary orders, the court will issue an order to appear, which you then serve on your ex, and that order to appear tells them when to show up for a evidentiary hearing on any temporary issues. This slide really gets into how do you prove your case, and we have an entire seminar series on how to prove your case, how to analyze different issues and put together what you need. But with regards to spousal maintenance, it's really important that you have evidence supporting your proposition. You need to document that there isn't enough money to pay the bills. Bring the bills, bring the bank statements. Don't simply claim that you've got expenses of $10,000 a month. Show it. Then you need to prove that you don't make enough money. So you bring your pay stubs, you show the bank accounts, you show, look, we've been combining everything for the last 10 years, here's how we got, et cetera, et cetera. And then any contributions that you've made to your spouse's education or career path. The person who wants maintenance has to show that they are not going to get enough property, including the property you're going to receive in your divorce, to provide for your reasonable needs. So let's say you don't have any income, but you've got an apartment building that creates, $8,000 in rental income each month. You may not need spousal maintenance. You may be able to have enough income from your property to not need spousal maintenance. Or you're unable to be self-sufficient through appropriate work, or you lack the earning ability in the labor market to be self-sufficient, or you're taking care of a kiddo whose age and condition requires the spouse not to work outside the home. Now, culturally speaking, we are in a period of time when this argument doesn't really fly. Most parents work. And just because you were a stay-at-home parent while you were married before someone filed for divorce does not mean that you are then entitled to maintain that status, even if you have a very young child. Now, it's different if, let's say, you just had a baby. Some daycares and, most people do not expect a mom to figure out how to support herself immediately after having a baby. So you've got a little bit of leeway. But at the same time, we all know moms who return back to work full-time after 6 weeks or 3 weeks. So it's really hard to say, what is going to count here. What is a little bit more complicated is when you have a child who has super special needs, and you are the person who's been taking care of that child and has the unique ability to take care of that child. And that absolutely happens, and it matters, and your spousal maintenance needs are going to be different than if you didn't have a child that really required your care. Another factor is, did you contribute to the educational or career opportunities of the other spouse? Let's say you help build your spouse's separate property business. So he brings a business into the marriage. It's his business because he brought it into the marriage. It's not community property, and you grow that business. That's going to be an issue. Or have you been married for a long time and you're of an age that prevents you from employment to be self-sufficient? So you've been married for 40 years, you're 65. You can't really be expected to go get a bachelor's degree and start a career in management. It's not going to happen. These are all things that you need to prove. Once you prove one of those, then we go on to this where we discuss the other factors in detail. So if you don't pass that step, what we just talked about, all those things, you don't get maintenance. You shouldn't really bother asking. Don't waste your time. But this is probably, so the first part is kind of the most important. And here is where, if we prove that you're eligible because you meet one of those factors that we talked about, you're not going to get enough property, you don't have, a kiddo who's so young or so disabled that you really need to take care of them, you're 65 and you can't go get a bachelor's degree. So once we've proven one of those things, then how much, how long? And everybody kind of wants to jump to, well, how much do I get for how long? But you can't jump there. You got to do the first part of the analysis first. And the court is required to consider your earning potential, not just what you're doing at the time. So you've been a stay-at-home mom, but you have an accounting degree. And okay, what is your earning potential? Well, maybe it's not what the accountant down the street makes because you've been out of the labor force for 10 years, but your earning capacity is not that of someone without that accounting degree, and that's going to be considered. The court, one of the things that you see a lot in spousal maintenance analysis is vocational analysis. And a vocational analyst or analysis comes in and looks at you individually and what your skills are and what you like to do and what's your career background been and what are the jobs available in the market near you. And then they make a determination of how much money can and should you be making. That is helpful for both sides of the spousal maintenance equation, both the person who is paying and the person who wants to get money. What are we going to look at? We're going to look at the standard of living. Here we need to be specific. So don't just say we travel a lot. Bring a calendar. So we took trips every 2 months for the last 5 years, and we stayed the 4 seasons. That's going to be important. That's different than saying we traveled a lot. Put together the numbers. Figure out we spent $15,000 a year traveling for the last 4 years. Okay, it's going to make a difference. That's different than just saying we traveled. The length of the marriage matters, mostly for duration of spousal maintenance. How much did you invest in each other, really, is the question, right? You had this partnership, you invested in each other. How long did you do that? And what position are you in now after your marriage? And then the ability of the spouse to pay. Just because you had the money to spend $15,000 a year traveling when you were married does not mean that that money is available now that there are 2 households and you're getting divorced. So even though the standard of living matters, the ability to pay kind of cancels that out in most cases, because most of the time you can't take what you had under one house and divide it under 2 houses and think that everybody's going to have the same lifestyle. Feel free to jump in if you want to. Okay. Comparative earning capacities of each spouse. we want to look at what is mom or wife able to earn and what is husband able to earn. If you're both lawyers and one just works more than the other, because let's say mom worked part-time while she took care of the kiddos, and now you're going to an equal parenting time. Well, the situation is changing. Like, you're making a big change. And so just because mom has traditionally made a lot less than dad doesn't mean that's always going to be the case. So if you were looking at spousal maintenance, it might be shorter than if you didn't have a law degree. And then there's this: how much did one spouse reduce his or her earning potential for the benefit of the other? Let's continue with the attorney example. Let's say husband decided he was going to go work at a big firm and become a partner, and he was making a lot of money, and mom stayed home and raised their 3 kids and worked part-time building a small estate planning firm. Not on Okay, on one hand, their income earning potentials are roughly equal, but not really. And how much money did she sacrifice supporting his career? What we've done in some cases is actually done a calculation. We've actually said, okay, when mom got married, she was making X. If she hadn't quit her job to stay home and support his career, and she would have earned X amount of raises per year, this is how much she'd be earning now, and here's the difference. So when you award your spousal maintenance number, judge, factor in this loss of $85,000 or something. And that analysis is called for under the statute, although you don't see it very often, and it's certainly not required. The other thing that the court looks at, which is kind of nice, is the ability to help kiddos go to college. In Arizona, child support ends at 18 or when a kiddo is done with high school. But if we're analyzing lifestyles and ability to pay, a reasonable expense is going to be paying for your children to go to college. That is contemplated in the spousal maintenance statute, which is super helpful. Do you have a question? No? Got it. Can the person seeking support meet his or her needs independently? That doesn't mean you're required to go live with your mom who has to support you, but it comes back to what do you have for liquid assets? Do you have a trust fund? Do you have a trust fund that pays you? Even if you maybe reduced your earning capacity, if you've got independent and alternative sources of income, or you're going to get Social Security in November and it's February now, all of this is going to be factored in. Do you have the ability to learn something new? Should you? Are you in a position where that needs to happen? Let's say you're disabled. You can't. You do not have the ability to go learn a new skill. You are mentally and or physically disabled. That matters in the spousal maintenance analysis. Has anyone behaved badly? Arizona is a no-fault divorce state, which means you can do what you want. You can cheat on your spouse. You can be a crappy husband who kind of doesn't come home and isn't very hands-on, and maybe put a really restrictive budget on your spouse. Or you can be a super naggy wife who, I just want to be fair, who has relations with the pool boy. You can, as long as everybody's an adult. And it's a no-fault divorce state, meaning it's not going to affect the amount of property you get or your parenting time or the child support analysis. But if spousal maintenance is to be paid and one person hid assets, overspent, let's say your one person had a affair and spent a lot of money on that person, off doing things, gallivanting about in ways that didn't support the marriage, that may be able to be recouped here under spousal maintenance analysis. And if there's waste, then that could come into a property analysis as well. Also, okay. If you misrepresent your income, that's going to come up. So let's say you try to hide money and you get caught. This statute allows for that to impact your spousal maintenance award. And we had a case like that not that long ago, where they were married for a long time. Somebody owned a medical practice. Wife worked and raised the parties' 4 children. She homeschooled them. She supported their practice. Um, he stopped working, moved in with his mistress, devalued his medical practice, and there wasn't a lot of property to split because the medical practice was gone at that point. So the judge used that as a reason to give her $3,000 a month for the rest of her life.
Do you feel like it's common during divorce for parties to attempt to hide assets?
Is that a question that came in?
Yeah.
Is it common in divorce for parties to attempt to hide assets or income?
Because since it matters in this scenario,
I mean, that's a tough question. Yes. I mean, most of this disclosure is voluntary. At the same time, the discovery rules, and we have an entire seminar on discovery, are really broad. So it sort of depends on the situation. If you had a couple that shared all information throughout all of their marriage, it's pretty difficult to hide information. Everybody had access to it. If you didn't have that type of marriage, and you had the type of marriage where everything was really separate and there was already kind of secretiveness going on, then yeah, it's pretty difficult to know if somebody's hiding assets. So for instance, in the example we just had, we were able to show, in that case, we actually found all sorts of hidden assets, bank accounts, judgments, and all sorts of hidden stuff. The downside is we try to keep our clients' costs as low as we can. And finding hidden money takes money. So we have to do a cost benefit analysis. What's the fastest way to figure out what's out there? What's the most cost effective way to figure out what's out there, and make sure that we're getting all of the accurate information? No problem. The cost of health insurance and future health expenses goes in there. And this is important because there was a while there, I feel like maybe health insurance costs have sort of leveled off, but maybe not. And there was a while there where somebody's health insurance could go up $500 a year. And that and the future increase was put into the statute as something that could be considered when figuring out the appropriate spousal maintenance number. So let's say you can meet your reasonable needs today and your health insurance is $200, but you know next year it's going to be $600. The court is allowed to consider that because of this factor in the statute.
So let's say you have kids or whatever, and they've done this projection, but then something changes pretty dramatically where like the kid gets sick, and so obviously healthcare in the following years is going to increase because of the way. Are you able to then go back and try to adjust, because now what you anticipated is very, very different than what's being played out year over year?
So a couple things going on there with that question. If it's your child, most likely you'd modify child support, because any changes to kiddo costs are usually handled that way. But at the same time, all expenses go into the affidavit of financial information to figure out child support or spousal maintenance. If a spouse, an ex-spouse, has a massive change in circumstance, are you allowed to go change maintenance and ask for more money from your ex?
Or less if you were the person.
Or less. Let's say you're
paying, but your circumstances changed.
Right, like you lose your job, or you get hurt or something like that. It depends on whether or not the decree says that the spousal maintenance is modifiable or non-modifiable. As a practical matter, when judges order spousal maintenance, it's always modifiable, and the law is set out on how you can modify that. Many times people will enter into private agreements for spousal maintenance that are non-modifiable, and that means they're non-modifiable for both people under any circumstance. I've been in a position before where I negotiated a clause for a client that was non-modifiable spousal maintenance to his wife, except in the event that he suffered an injury that would not allow him to work. because he was in the type of work where that could happen. So you can, if you're negotiating, you really want to think about this on behalf of yourself or your client. Yeah. Past abuse. If you have been abused and you have suffered injuries, you have damages, and you are allowed in the family court under this provision to request financial damages, liquid damages for those injuries that you have received. You also have the ability to recoup money under restitution under a criminal case or sue for battery and damages under a civil case. What's income? Income is wages, commissions, dividends, bonus, severance pay, workers' comp, annuity, capital gains, maintenance that you might get from somebody else, unemployment benefits, disability benefits, Social Security benefits, not child support, not veterans disability benefits, not welfare, so TANF or that sort of thing. Food stamps are not income, but most thing, what is those funny? Yeah. But it, yeah, I mean, it does impact your expenses. So on the affidavit of financial information, you want to be clear about that. Excessive spending and marital misconduct. So we don't care if you had affairs, but we do care if you flew around the world and wasted money traveling on your person that you were having an affair with. Community waste is when your ex wastes money that was community property. So you guys worked and all the money went into the joint account, and then one party went to the casino and gambled it away. That was not, as long as the person didn't know about it. Now, if they went gambling together, that's entertainment. So the line between waste and entertainment, is a fuzzy one. But did you know about it? And was it in furtherance of the community or not? And waste can affect spousal maintenance. Drugs. So somebody spent a whole lot of money on drugs. That's not really in furtherance of the community, and you may have a waste claim there.
But it has to be waste you didn't know about.
Yeah, there's a case with more factors to analyze waste. But one of those factors under this case is, did you know about it? There's no guidelines, there's no calculator, but a while back, some Maricopa County judges came up with a mathematical guideline to use as a formula after the threshold eligibility was determined. So after they determined that they met a factor that allowed them to qualify for maintenance, they came up with a calculator and a formula to say, okay, how much and for how long, and then checked it on the actual words to see how accurate it was. And we have that calculator on our website. You can feel free to play with it. As a practical matter, it's not binding, and the awards of spousal maintenance have in general been simply decreasing in both amount and length. As a public policy kind of cultural shift, there just seems to be a lot of, we're moving away from the idea that one spouse should continue to support an ex-spouse. It's not always the case, but definitely a trend, and not a subtle one. The guidelines and the calculator that you can play with on our website, mymodernlaw.com, is based on expenses, your income, your age, how long you've been married. And here's the actual formula if you feel like doing it without using the calculator on our website. If you're a math person and you want to play with it, go ahead and screenshot that. And here's an example. Here, Joe and Vera, married 20 years. Joe's 42. He's an attorney who earns 100K. Vera's 40 and she works part-time at a school making 20. Step one, how long were they married? And then you apply the 0.15 formula. Then you take his monthly income and subtract hers to find out what the difference is. Then you multiply that number that we came up with, the number 2, by the multiplier in step 1. And that tells you how much the spousal maintenance is. Then to figure out how long the spousal maintenance should ask, you take 20 years and you multiply that by anywhere between 0.5, 0.3, and 0.5. So in this case, using the Maricopa County guidelines, Joe and Vera, Joe would pay to Vera $1,999 for anywhere between 6 and 10 years. This goes to the modifiability question, and we talked about that a little bit. If there is a significant, continuing, substantial change in circumstances affecting the purpose of the original decree, then you can ask for a modification. So this cannot be regular raises. It cannot be an anticipated retirement. Oh, okay. And then, did you want to restart it? Got it. No problem. So let's say, you had certain considerations when you entered into your spousal maintenance award. The judge said, you were going to go get a 4-year degree and then you would be a nurse and you would be able to support yourself. And so the spousal maintenance award was for 5 years. But the school gets shut down, or you get in a horrible accident, or something happens that frustrates the original purpose, then you can go back and ask for a modification. Everything okay?
Well, I feel like even though you look really great on this one, that maybe it's not quite the same for people viewing.
On Insta or Facebook or both?
I think maybe on Facebook it's just like.
Well, we'll post the video later. We can keep going. I'll try to wrap it up if that helps. We're good? Okay, or you can always stop it and we'll just post it later. Okay, so what if you're not getting your spousal maintenance? It's been ordered and the person who's supposed to pay it is not paying it. You can't collect this quite as aggressively as child support. It's unlikely that somebody's going to be thrown in jail for failing to pay spousal maintenance, but you can get a garnishment. You can get, you can seize, you can seize items of property or assets. You can get a quadro, so a piece of their retirement fund. You want to create a lien, and in order to do that, you need to record the judgment and file the lien. And then you can ask for security interest like a piece of property or a house or a mortgage in order to back you up on that. Now, tax laws have been changed, and if you get divorced by the end of 2018 and you are paying spousal maintenance, that maintenance is deductible as income to you and taxable to the recipient as income. After 2018, the opposite is true. The person paying the spousal maintenance will pay the tax. The reason is that the person who pays spousal maintenance is usually in a higher tax bracket because they, by definition, make more money than the person who receives the spousal maintenance. So by having the paying spouse pay the tax, the government will end up getting more dollars. This is a big, big change with big, big impacts that need to be fully considered, both on the timing of your divorce, on the decision of spousal maintenance, and on the amount of spousal maintenance. That is where we are ending for today.